Welcome back, COS supporters. It's another edition of COS Live. My name is Andrew Lush. I'll be your host. And of course, I'm joined by Rita Peters, my co-host, but also the Senior Vice President for Legislative Affairs. Rita.
More than 117,000 Ohioans have signed the Convention of States petition asking their state legislators to vote yes on COS. According to a study by the Trafalgar Group, almost 2/3 of Ohio voters, 62%, favor the state calling an Article 5 convention to propose constitutional amendments that limit federal spending, limit federal power, and establish term limits for members of Congress, maybe even federal judges and bureaucrats.
Next, I will call up Dr. Michael Farris. Dr. Farris, I see that you submitted proponent testimony for this and HJR2. We'll do 67 first, and if you could stay up there, and then we'll move to HJR2, if that's okay with you.
Thank you, Mr. Chairman.
I believe there's only two in-person testimony for HB 67. So proceed when ready on House Bill 67.
Mr. Chairman Hall, Vice Chairman Ferguson, Ranking Member Humphrey. Again, my name is Mike Farris. I'm a constitutional lawyer. I'm the co-founder of the Convention of States Project. In addition to having practiced constitutional law for getting close to 50 years, next year will be my 50th anniversary. I also have taught constitutional law at the collegiate level for 17 years. I have also, one of the few lawyers in the country who's actually litigated a case about the amending process involving the efforts of Congress to change the rules for the ratification of the Equal Rights Amendment. I litigated that back in the 70s and 80s. This bill is a bill that should be supported by everyone, regardless if you think it's a good idea to call a convention or not. If there's ever going to be a convention, whether Ohio participates in being one of the 34 states that calls a convention, if a convention's called, you're going to have to appoint delegates. You're going to want to be represented in that. You don't want to be absent. So how are you going to name your delegates? How are you going to control them? What's the process going to be? That's all this does. It has no bearing as to what the topic is. HJR2 is about a topic. This is not about a topic. Whether it's term limits or this or repealing the Citizens United that some people are working on, it applies to every convention on any topic at any time. Now, there are three key principles. One is the delegates are appointed and controlled by this body. That's historically accurate way to do it. In the 1787 Constitutional Convention, every state gave their delegates instructions, and those were followed. Two quick examples. New York gave its delegates instruction that all three delegates had to be present to vote. About July of that year, two of the delegates got mad and went home. Alexander Hamilton stayed. Hamilton continued to debate, but New York was never allowed to vote again because New York's instructions from the legislature were all three had to be present to vote. So New York stopped voting when those two delegates left. The other example, Delaware said that there had to be a system where the states were equal. And so the convention followed that. Was one of the reasons that the bicameral process was created, with the Senate being equal states. So the delegation from Delaware under instruction from their legislature, which was followed by the convention, is an example of this. So whatever the state tells its delegates to do, that state is entitled to see that that's enforced. There are two key rules for a convention that people are legitimately concerned. No right-thinking person wants an unlimited convention where you can propose any amendment on any subject. I don't know anybody, right, left, or center, that wants that. There may be some radical person someplace. I've never met them. The two key rules are this: you can't change the subject at the convention, and secondly, it's one state, one vote. I'll cover the you can't change the subject matter in my second testimony if I can, but you can't change, the one state, one vote is also very important. There are penalties attached to this that are both removal of the person and criminal prosecution if there's a deliberate defiance of the limitations imposed by this legislature. And with that, Mr. Chairman, I would be glad to answer any and all questions that you might have about this.
With regard to your testimony today, my understanding that at a convention, the delegates become federal agents. and that they are sovereign once they get to DC. How would you suggest that Ohio would enforce our laws against a federal agent during an Article 5 convention?
Well, Mr. Chairman, to the representative, your information is incorrect. They are not federal agents. The delegates are representatives of the state, appointed by and controlled by the legislation. There's no history, there's no legal precedent. They're agents of the state. And the recent Supreme Court decision in 2020 of the Chiafalo versus Washington relative to electors, members of the Electoral College, the Supreme Court of the United States clearly ruled that the electors are controlled by the states. The rules that are set by the state legislature must be followed by the electors. There's no basis for saying presidential electors are state controlled, but members of a Article 5 Amendments Convention are not state officials or state controlled personnel. They're identically from a constitutional perspective.
Follow up.
Thank you, Mr. Chair. So since we can appoint anyone, and we liked Taylor Swift last year, we could appoint Taylor Swift as one of our delegates. And what you're saying is if she was an Ohio state resident, that once she went to DC, that we would be able to enforce Ohio law at the federal level.
Mr. Chairman, Representative Gross, there's a difference between constitutional activity and federal activity. The Second Amendment is a federal constitutional right. That does not mean that Congress acquires the ability to regulate guns because there is a federal constitutional right. You have to look to an enumerated power of Congress to claim the right to regulate guns. The First Amendment protects freedom of speech, freedom of religion, freedom of assembly, and so on. That does not mean that Congress has the authority. In fact, it says to the opposite. Congress shall make no law relative to these things. So there's constitutional level issues and there's federal level issues. There are statutory level constitutional issues. There are regulatory level constitutional issues. There's executive branch constitutional issues. The word federal is not all encompassing, that anything that has the word federal attached to it is controlled by the same process. This is controlled by Article 5 of the Constitution of the United States. These are conventions of states controlled by the states, appointed by the states. The whole purpose of Article 5, this aspect of Article 5, was to give the states the unilateral ability to override federal abuse of power, and the federal government has no substantive say in the matter. The states were given and control a unilateral process. And the fact that there's so much federal overreach, and every state legislature in this country debates day in and day out, we got to comply with this federal regulation, we got to comply with that federal regulation. Every single one of them, I would submit, almost every one of them, is unconstitutional. And you should be resisting that, not complying with that. And this is the process that you throw that kind of tyranny over permanently. And so to say that they're a federal constitutional the appointed person does not mean they're subject to control by Congress or the president or the executive branch or any agency. Just not how you read the Constitution. That's not how the Constitution works.
Your colleague, Mr. Santorum, is on record and was recorded stating that we should have an Article 5 convention every 5 years. How would you answer that question?
Mr. Chairman, Representative Gross, obviously, nobody can control how often a convention would be called. It's very hard to do. It's extremely hard to do. This has been going on for about 12 years of my active participation in the process. And so if it could be, I doubt that everything that I would like to get accomplished, I think the federal government ought to be restricted pretty strenuously or restrictively. I'm not sure that it'll all get done in the first one. And so I would be open to having a second one once America sees how the process works, because the best thing that comes out of a convention like that works and works safely is the states know they've got a weapon in their arsenal now that balances out their power against the federal government. No longer are you guys the minions of what people in Washington want you to do. You're the parents. And my wife and I have 10 children. 31 grandchildren, 1 great-grandchild. You take over America your way, we'll take over America our way. I think I'm an expert on what would happen if you didn't discipline your kids. If you discipline your kids, you're gonna get good kids. You don't discipline your kids, you got a mess. The states are the parents. And for 250 years, we failed to discipline the kids. Well, this is time for the parents to get in charge and tell the feds, you guys are the kids and we're going to take away your credit cards and some other stuff. And that's the best thing that can come out of this. And if it's every 5 years, every 7 years, George Mason gave us this methodology because he said someday the federal government's going to abuse its power. And if you think the federal government's abusing its power, let's do something about it. And if they continue to abuse their power, let's do it again. But we should do it as often as the federal government abuses its power. Once they stop abusing their power, we don't need to do this anymore.
Last question.
Thank you, Mr. Chairman. Thank you for your testimony today. Speaking of disciplines, so what happens to a delegate who doesn't follow script? What is the recourse for the states?
Mr. Chairman, Representative Sims, I want to address technically the word script and then address your question. There is no script. There are things that are off topic. And the basic instruction of this state to the delegates is stay on topic. If you're sent to do fiscal restraints and term limits, you don't bring up changing the process for the Electoral College, okay? You stay on topic. Whatever you're told to go and do, you stick to the topic. So you can't, with integrity, give them an actual script. They should be given the marching orders that says you will stay on topic, you'll be faithful to the command that you've been given, and with that, you let them go and be responsible representatives of the state who will have the freedom to debate and think through things and hear arguments from other states and make good decisions. That's the process that this will be about. And but if they violate the rules and they go off topic and start pushing things that are outside the zone, then you can recall them. And if it's purposeful, you can criminally punish them. That's what the bill specifically says.
This is a little bit more broad. In the bill analysis or the resolution analysis, talks about the second one, specifies that the convention is limited to proposing amendments that impose fiscal restraints on the federal government, limit the power and jurisdiction of federal government, limit the terms of office for its officials and its members of Congress. We've heard HJR 3 as well, so it is a little confusing. So
I apologize.
No, apologies. No worries at all. Yes, Dr. Farris.
Mr. Chairman, Representative Gross, there's far more that's need to be done than term limits is one of the topics that's germane. This legislature, of course, is free to vote for both. There's no reason you shouldn't vote if you support them substantively. If you support the idea of term limits on federal congressmen, you can vote for HJR 3, and it does no damage to HJR 2 one way or the other. If you like the idea of term limits on all federal officials, including the possibility of federal judges, including the possibility of federal officials like Dr. Fauci, then our language for term limits is broader than the language in HJR 3. But the idea that we are doing something violent to the Constitution and that 315 members of Congress, if that's the correct number, over 300 members of Congress have been replaced over the number of years that you stated. That's an interesting and an important argument about term limits. The number I would give you back is $39 trillion. $39 trillion. I had a bumper sticker on my file cabinet when I was first a lawyer. It said, "No $1 trillion debt." We're now at 39 trillion of the amount that we count. If we did regular accounting principles, the amount that we've stolen from the Social Security Trust Fund and so on, it's north of 150 trillion is the real national debt. And so that's the number to me that no matter which the members of Congress are, we have to do something structural to stop the runaway spending, stop the runaway debt and do something to bring the federal government under its responsibility. Thank you, Mr. Chairman.
Representative, let's go Vice Chair Ferguson first.
Thank you, Chairman. Thank you for coming in for your testimony. This one, I might have differences with my colleagues on the Republican side, sometimes those with the Democrats. And that's why the premise of this question, I just ask, we have turnover here in this legislature. And so what's asked in a lot of these calls of conventions is that we just broadly say whenever a convention is going to be called, Ohio will be there. But, I have term limits, and Rep. Gross, for instance, I don't really feel comfortable necessarily saying that the next legislature and the one after that and the one after that and the one after that should all be going to a convention. So the question being, would you be supportive of us doing this on more of a rolling basis, meaning like every 2 years we would have to re-up the call for the convention because what the topic might be might vary, who's elected in this legislature might vary, and that's really, I'll leave it open-ended to you.
Okay. Mr. Chairman, Representative Ferguson, thank you so much for the opportunity to clarify. There's a bit of the first bill and there's a bit of the second measure in your question, if I can address them both a little bit. A delegate appointment bill, HR 67, gives you a process for whenever you're going to have a particular convention, and that's essentially timeless. There's no reason. You're going to want to appoint delegates. You're going to want to give them instructions. You're going to want to say how they're appointed and who they report to and things like that. That's, it's non-controversial from my perspective. It's just straightforward stuff, and you can give them additional delegates or instructions rather when it comes to a particular convention. An application, HJR2 is an application. You can time limit it if you want to. A few states have, both states that I'm recalling, Oklahoma and Texas. Oklahoma did, they had it for 5 years originally, and then they rescinded that later. Texas had 5 years, and they're in the process of rescinding it right now, and I don't know what the status is. I know that's going on in this legislative session this year. And so it's been done. Okay, thank you. So but applications last as long, but they're only per that topic. And so Ohio has passed applications in the past, and those are good until one of two things happens, or three things. One is you rescind it. You can rescind any application at any point in time. When you do, it's gone, or at least Ohio's participation of that is gone. You can't, or if there's a convention held on it, then okay, it's been used up. If you put a time limit on it and that time limit passes. So the basic rule is whatever you say about how this works for Ohio, that controls. So if you want to put a time limit on HJR2, I would ask you not to put 2 years because the process of getting done just takes longer than that. But if you wanted to put a process on it, I would suggest 10. And so the states that did 5 found that to be too short of a time. But I like the idea of things being roughly contemporaneous. And I think that 10 years would be a good amount of time. So if you want to make sure that this topic is limited to, if you don't bring it up in the next 10 years, then you got to start over. It wouldn't be my favorite, but I wouldn't have really any objection to that. Is that responsive to what you're asking? Okay.
Thank you, Vice Chair. Representative Rader.
Thank you. This is actually be kind of a follow-up to Representative Ferguson, and thank you again for sticking around. So Ohio has passed this, like you said, the resolution a couple of times. I think the first time was in 1861, quite a while ago, for a general convention.
Right.
I guess my question is, why wouldn't those currently still stand or apply? Sometimes when people are counting how many states have passed this, they already include Ohio as passing it because the last time we passed it was in 2013 for a budget, for a balanced budget, right? Which is similar to kind of what we're talking about here today. So if we were to pass it again, or we're just to be added to the pot, why wouldn't we already automatically be calling for a general convention where any topic can be discussed and deliberated on?
Mr. Chairman, Representative Rader, the Ohio's 1861 resolution, if you have not repealed it, and I don't think you have, it's still in place and is valid. And it would aggregate if 34 states called for a general convention, it would aggregate with those. It will not aggregate with those that have called for child labor amendment or right to life amendments or redo one man, one vote amendments. It aggregates only with other amendments on the same topic. And there have been approximately 14 general applications in the history of our country, never 34, and most of those have been subsequently repealed. I don't have an exact count, but I think it's about 5 that are extant right this moment. But they only aggregate with others of like kind. And so your balanced budget application is still valid, and it aggregates with other balanced budget applications, provided that they're not too particular. For example, Mississippi's application says they want to have a balanced budget, a convention for a balanced budget amount, and they provided an exact text and say, we call a convention only for this text. It aggregates with nothing else but itself. Mississippi's going to have to do it over again if they're going to want to join a general call for a balanced budget amendment. So when like joins like, if you think of it basically like the process of a House passes a bill and the Senate passes a bill that's similar, that's not law. You got to agree on the exact text. And when there's an agreement on the exact text, when there's an agreement on the topic, then you've got a convention. There's no agreement on the topic, you don't have a convention.
Got it. Thank you. I think I just want to clarify, I misspoke. 34 is the number you need. I think 28 states have passed some version of this up to this point, is I think what I've read. On different topics calling for some type of Article 5 convention. Is that right? I don't know.
Mr. Chairman, Representative Rader, 49 states have called for a convention on something. And but there's never been 34, 2/3 of the several states on a single topic.
That's helpful. Thank you, Mr. Chair.
Any other questions? Seeing none, thank you so much, Dr. Farris, for your testimony.